start, and only in the year 1983, when the appellants came to know of the said illegal change in the said mutation entry, they moved the Revenue Authority, and by mutation entry number 666 dated 26th September 1983, the appellants were able to incorporate their own names based on the aforesaid sale deed dated 26th September 1951 with regard to the 2 annas and 8 pi share in the said will. Stop. Since the appellants were not given any notice whatsoever with regard to the mutation entries, the respondents' contention that the appellants ought to have objected does not arise at all. Stop. Unless and until proper notice is given to the appellants with regard to the proposed change in the mutation entry, there was no case for the appellants to raise any objection against this lower appellate court's order dated 16th November 1989. The present second appeal has been filed. Stop. The learned counsel for the appellants had raised two substantial questions of law, viz. Mutation entry by itself does not confer any title or legal status with regard to any immovable property, the co-owner cannot claim any order of injunction against another co-owner with regard to the property owned jointly, It is an admitted position that as per sale deed dated 26th September 1951, the appellants herein are the owners with regard to the 2 annas and 8 pi share in the said will, and the balance left out, that is 13 annas and 4 pi share, is owned by all the respondents. Stop. The learned counsel for the appellants had relied upon the following two authorities with regard to the first proposition, that the mutation entry by itself does not establish any title to any immovable property. Stop. The first authority is State of Himachal Pradesh versus Keshav Ram and others. Stop. The Apex Court in para number 4 has dealt with this issue in a very lucid and clear manner. Stop. The said para number 4 reads as under para. In view of the rival contentions, the question that arises for consideration is whether the plaintiffs have been able to establish their title, and the courts below were justified in declaring plaintiffs' title. Stop. As has been stated earlier, only piece of evidence on which the courts below relied upon to decree the plaintiff's suit in the alleged order made by the assistant settlement officer directing correction of the record of right. Stop. The order in question is not their own record. Full stop.